process. You know, like, but she, like, obviously she went with it, like, so she had to keep going with it, you know?
It's a crazy case. Alright, what's next on the agenda? Okay, Shaw versus Reno. This was another court case which had to deal with district lines and how the votes were valued in terms of the election. So this one established that there should be, or that racial gerrymandering was unconstitutional. Race cannot be the sole or predominant factor in redrawing district lines or boundaries. And this also established that there can't be a majority or minority district. So whether or not they redraw the boundaries at any given time, it can't have anything to do with race, or it can't have anything to do with particular minorities. And the U.S. Attorney General rejected a North Carolina congressional reapportionment plan because...
Oh my god, did you just burp?
Yeah.
It happens, ladies and gentlemen.
Excuse me. Because it created only one black majority district, so it was unfair in terms of the election. So that case established that that was unconstitutional. And that happened in 1993.
Interesting.
Alright, let's see. Oh, you set out the nachos.
I had to go for them.
Oh, they're kind of like soggy, but...
It's because they've been sitting here for a little bit, but it happened. Okay, next up we're gonna hit Brown versus Board of Education of Topeka or Topeka. Topeka. Okay, we learn something every day, folks. Am I right? And that happened in 1954. That was when, oh my gosh, I almost dropped the nachos on the floor. That was when the Supreme Court overruled Plessy versus Ferguson, and the declared racial segregation facilities are inherently unequal, and ordered the public schools to desegregate. And what basically happened with this is a consolidation of the cases arising in Kansas, South Carolina, Virginia, Delaware, and Washington, D.C., relating to the segregation of schools on the basis of race. So basically, they would split up the African Americans with the white people, if you don't know what segregation means. It was a really big thing, you know? Can you stop laughing, please? Thank you. I'm letting the public know the information, okay?
Miss Escobar, if you don't know what
now you know.
is.
And then, in the end, it argued that segregation violated the Equal Protection Clause of the 14th Amendment.
In that case, opened up the whole civil rights movement. It was the first success that they have, and it launched a lot of stop. It launched a lot of successes that followed after that, so it was super cool.
And this one was actually a main topic on the 2019 AP Government exam. Woo! I wasn't expecting it, so we'll see how we do. Am I right?
Alright, so next
really got me there.
We have Schenck versus U.S. So, this one, I always remember as Schenck speech. Schenck speech. So basically, socialist Charles Schenck wanted to distribute flyers to recently drafted servicemen of World War I that described the draft as an involuntary servitude. So he was basically saying that the draft was like kind of like slavery in a way, and that it violated constitutional 13th Amendment right, which abolished slavery. And he wanted to petition against the draft because it claimed the war was happening on the basis of capitalist greed, and that happened in 1919. So issues that arose in this case were that it claimed the draft as a violation of the 13th Amendment, and again, it established it as involuntary servitude. But the court decision, it was that it was charged by the U.S. government in violation to the Espionage Act. In response, Schenck declared that the Espionage Act violated his First Amendment rights, so they were telling him that such an act of speech was espionage against the government, especially in times of war. And he was eventually found guilty on all charges, which I thought was kind of crazy that it went that far. But the reasoning in that was that the Espionage Act did not violate the First Amendment. The court ruled that Schenk's use of free speech created a clear and present danger of unsubordination in wartime, and that the character of every act depends upon the circumstances in which it is done. And I thought that made a lot of sense when I was learning about this, because I feel like it would have been different if he was talking, like, against the draft in times that weren't war, because he was basically telling everyone to go against, like, the country and, like, the government and, like, even, like, protecting it. So that one made sense to me. And this was super significant. Oh, what else I found was interesting was that the vote was unanimous, so everyone agreed in that it wasn't best to speak out against the draft, I guess. And it was significant.
Everybody needed to come together at that time.
Yeah.
They couldn't have any, like, thoughts of it. Like, it happened a lot during the 70s, too, especially with the
Vietnam War.
Yeah, that was crazy with all the, as you would say, hippies protesting and not doing anything.
Forrest Gump.
Yes, Forrest Gump, or that one movie with Liam Hemsworth, where he leaves. It's like Love and Honor. You should watch that, Miss Escobar, if you haven't. It's a real good one.
I've never seen it.
Sucks.
That's a personal opinion that I did not ask for.
Wait, anyways, yeah, well, it was clear and present danger at times of war, so that was what stood out in that case. And it was significant in that it led to a balancing test. So basically, the court began to assess free speech challenges of every case. So every act of free speech, they would have an assessment, and
Those
they
are
would...
horses.
Yeah, it's the Del Mar racetrack.
Really?
Yeah.
Did you paint it?
No, we found it. But they would,
Raise one up for the boys, am I right?
You keep making me lose my train of thought. Oh, but they would see how it was relevant to the times in each act of free speech. So that was significant too.
Okay. And next up, we're going to hit it with Angle versus Vitale. And that's in 1962. And it struck down the state-sponsored prayer in public schools, and it ruled that the unconstitutional violation of the Establishment Clause. I sound like every guy ever. That happens when the New York State Board of Regents or something authorized a short voluntary prayer for recitation at the start of each school day. A group of organizations joined forces just to say that it was unconstitutional and it violated the Establishment Clause. And then the New York court rejected their arguments. But in the end, the states cannot hold prayer in public schools, even if the participation is not required, and even if it's not, like, centered on one religion.
Yeah.
Which is, like, understandable. I mean, you can't just... Some people might, if they don't want to partake in that, they might feel awkward and just not like it, you know?
And that's even become relevant today in that it's becoming controversial for some schools and some families to even stand up and say the Pledge of Allegiance in class. Because it contains the one nation under God clause.
Under God. I'll still stand up for the pledge. That's just me. I know some people do sit down, and it's whatever your decision is, you know?
Everyone has rights. Alright.
Until your rights are taken, and then we need to, like, fix something.
Oh my goodness. Could you imagine? Alright, the next case we're going to talk about is one that is very near and dear to all of our hearts, as it was one that we were first introduced to in APUSH. Marbury versus Madison.
Ooh, I knew this one was coming.
Jefferson and the Midnight Appointees.
Hold up, we're pushing 23 minutes. Let's get it.
Wow. Alright, so Thomas Jefferson defeated John Adams in the 1800 presidential election.
I'm taking the last chip.
Go for it. Majority was held by Democratic and Republicans in both chambers. Basically, the issues were that John Marshall was appointed as Chief Justice by John Adams, but before Adams left office, he packed the courts and created the Midnight Appointees. So before he left, he attempted to pack the courts in hopes that his beliefs would stay while he left. He failed, however, to send commission to Marbury. March 4th, Jefferson ordered Secretary of State James Madison to not deliver commission, so they tried to stop the midnight appointees from kind of taking over. And Marbury sued because he didn't get his commission. It said that Marbury claimed that he was entitled to receive such commission, and eventually John Marshall established that Marbury's commission was signed by the Secretary of State. They said that failure of commission sent to Marbury was an infringement upon his legal right to office. They also ruled that the Supreme Court could not order delivery of the commission because the law established such power. The reasoning was, although Marshall declared Marbury was entitled to his commission, the Supreme Court could hear the case caused because of original jurisdiction. So this case was super important because it established original jurisdiction. It also established the Judiciary Act, or that's what was also incorporated, also Article 3, Section 2, as well as Article 2. This was significant because holding out of Marbury versus, Marbury receiving his commission established Supreme Court power of judicial review. It also established a branch of government to determine validity of inconsistent laws. So Jefferson won new power not written in the Constitution, so judicial review was established in this case.
That was a long one, but it was a good one. Okay, and next up we're going to hit Wisconsin versus Yoder. And that happened in 1972, and that's another case that has to do with religion and the idea of that. And so that's when Amish people refused to send their children to school past 8th grade, when the school state required all children to still go to school until the age of 16. And just saying that, like, past 8th grade, that's where their religion takes place more, like, frequently, and they need to be more involved in it. Mm-hmm. So they wanted to take their children out because it was an idea of religion. And the law is in conflict with the free exercise clause that, like, stop them from being able to take their children out. Mm-hmm. And the state is in direct conflict with the Amish beliefs, so the Amish may teach themselves, and it basically ruled for the Amish. Mm-hmm. And, like, in favor of them, like, to be able to, like, actually practice their religion the way that they intended it to.
In that they could not go to school.
Mm-hmm.
If they wanted.
Must be nice.
Is that your last case?
Yes, ma'am.
Alright, so I got one more, guys. Hang in there.
I didn't know you had so many.
Gideon versus Wainwright, 1963. So we'll keep this one short and sweet. The Supreme Court case in which the court ruled that the defendant in a felony trial must be provided a lawyer free of charge if the defendant cannot afford one. So this is a guy that broke into the pool house and had no way to have a lawyer represent him, and he demanded representation in the court, and he said that was a right, and it was. Clarence Earl Gideon was charged in Florida State Court with felony of breaking and entering. Gideon requested that the court appoint an attorney for him, and the attorney was not given since it was not a capital crime. And then the Sixth Amendment guarantees a right to assistance of counsel, so that just established that in court, no matter what the crime, the defendant is always allowed to have a representative to help defend their case.
Was that it?
That's it. And that happened in 1963.
Well, folks, that's all that we got for you today. Thank you for watching our talk. I'm not going to add the word in front of it because we might get
copyrighted.
Yeah, copyrighted.
It's the Esquivel talk.
Yes! Thank you. I try to keep it short and sweet. Paula did a little bit long. We'll see how it goes. You know what I'm saying? But, bye guys.